a payment.
You have not provided me an answer, but under what
yes,
law?
Yes, ma'am, I did. The answer I gave you was that it was your obligation. Mr. Freehouse, please
ma'am, I need to finish what I have to say.
Guys, today we are stepping into a courtroom where tension is already simmering before the case even formally begins. The judge calmly outlines the procedure, but notice the subtle friction in communication and the refusal to enter a breakout discussion. This moment quietly sets the stage, revealing that this won't be a routine hearing but a contested legal clash where structure, process, and expectations are about to collide.
Individuals are here on behalf of D23 LLC, and they were asking if perhaps I could put you guys in a breakout room to discuss whether or not, just briefly discuss whether or not there might be some agreement that y'all could come to. Is that something you would be willing to do, Ms. Ballard?
No, not at this time.
Okay. Ms. Akpati? That's the announcement I've gotten. So can you tell me, Ms. Ballard, what... I'm not going to call your case formally right now. Right now, what I'm looking for is how long do you think that it will take to present what you want to present to the court today?
To my understanding, has the court reviewed the affidavits that has been submitted?
Yes, ma'am, I have.
Okay. So what can I expect as far as procedure? How will this hearing go?
Well, so typically what will happen, because you are the movant, you're the person who's seeking relief. So I would call on you to make any presentation that you would want to make. Sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made, and then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movant, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But right now, at this part of the hearing, what I'm typically doing is just asking the parties to tell me, how long do you think it will take if you wanted to make a presentation to me, Ms. Ballard, or if you want to rest on your briefs, you can do that. But if you wanted to make a presentation to outline verbally for me what you believe are the important issues, how long would that take?
I'm not sure. To my understanding, with this hearing, I was under the understanding that the affidavits that have been presented are fully understood, and that based on what I have submitted, that there would be a proper decision and ruling.
Okay. So I'm interpreting that, Ms. Ballard, as you wanting to rest on the materials that you've sent, and that's perfectly fine. Ms. Akpati, what presentation, if any, did you intend to make? I'm just trying to get a time idea of how long this might take.
5 minutes, y'all.
Okay. Natasha Ballard versus D23 LLC, which is an appeal from a dispossessor.
Here's where the heart of the dispute first surfaces. Miss Ballard firmly establishes her position, rejecting the idea that she is even a tenant and challenging the opposing party's ownership altogether. This is not just a defense, it's a foundational attack on jurisdiction and legitimacy. Her insistence on no contract and priority interest signals a deeper legal strategy that immediately raises the stakes of the entire case.
Order in magistrate court. Ms. Ballard, as I mentioned, I have reviewed the petition that you filed with the affidavit that was accompanied it. And so did you wish to make any oral presentation here at the hearing, or do you want me to rely on what you have submitted in your briefs, which again is fine. You may do whichever you wish.
Sure. So from my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity, I'm requesting that this motion under the titles, under the Rule 60B, that, I mean, this is thrown out. I mean, it just, we don't have a contract. There's nothing to really argue here. So, I mean, it's clearly displayed and stated in the affidavits that I submitted. And bottom line, we don't have a contract. The other entity does not own this property.
Okay.
I have priority interest and equity in this property.
Okay. Thank you, Ms. Ballard. As I said, I have had a chance to review the magistrate court file and the appeal materials that you filed in this case. One question I did have, Ms. Ballard, is that part of the order that was entered against you, which you are challenging here, right? That the magistrate judge's, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that and you're challenging that order. And I understand that part. But part of the order also
Now things start getting serious as the judge zeroes in on a critical procedural requirement: payment into the court registry. Miss Ballard confidently claims full compliance, but the opposing counsel directly contradicts her, stating that no payment exists on record. This is a pivotal credibility moment, where the case begins shifting from abstract legal arguments to verifiable evidence, and the tension noticeably escalates.
requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment, and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put an affidavit to ask for rent. So, and there's no contract. But I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Brooks.
Okay. I am going to call on Ms. Akpati for her response right now, Ms. Ballard. And then, as I said, because you're the movant on this matter, I'm going to call on you and let you have a chance to respond. Okay. Ms. Akpati?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning, and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because, again, as of 15 minutes ago, no payment has been made, or the court is not aware of any payment being made.
Yeah, I have looked in both the magistrate court file, which is often where those payments will go, and I've looked in this action. And the financial documents don't indicate that any payment has been made in either case, other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. Excuse me, by the defendant D23, the filing fee. Ms. Ballard, do you have any documentation? I'm looking at the file and I don't I don't see anything that indicates payment. I'm happy to follow up with the court because sometimes the clerk it gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment or what did you file?
It is basically a money order.
Okay, so where we are right now procedurally is that there is a dispossessory order that was entered by Judge Brooks on December the 7th that awarded a money judgment in the amount of $459.40 to Ms. Akpati's client, D23, and then also ordered that any rent amount in the amount of $998.11 had to be paid on the 5th of each month, beginning, let's see, with January the 5th. But that would have required a prior payment in December. And there's no, respectfully, Ms. Ballard, I don't, if you can provide me with some documentation of the payment, I'm happy to pursue that with the clerk of court and find out if there is some issue with it being credited to the wrong file or something like that. But absent any such documentation, there's no evidence that the required payment has been made either into the magistrate court or into the superior court file. And absent that payment being made, the order that was entered very clearly says that if tenant appeals the judgment and wishes to remain in possession of the property, those payments must be made. And so that would typically mean that the dispossessory order would be issued in Stanter and D23 LLC would be entitled to possession of the property in Stanter, which, would mean immediately. Do you have any additional documentation that you could perhaps email to Mr. Freehoff and copy Ms. Akpati on so that I could see it and then follow up with the clerk regarding what happened to a payment that you made?
So I tendered a payment into the court of registry. If my payment was not accepted, I would not have received a case number for this case right now. The payment was accepted. It had to have been in order to get this case number.
Actually,
so I have to feel that.
Actually, that's not correct. So the file indicates, Ms. Ballard, the file indicates that you submitted an affidavit of poverty and that poverty affidavit was granted for the filing fee. So you didn't have to pay a filing fee to be able to open this case.
Respectfully, I tendered a payment in the magistrate court.
Right. I'm not questioning, Ms. Ballard, that you did. What I'm saying is I need some documentation of that payment because there's no such payment reflected in the magistrate court. And so if you have a receipt, if you have a copy of the money order, if you have even a bank transaction indicating where you withdrew that money from, or where you obtained the money order, that would be some information that I could then go to the clerk and say, hey, I've got a party telling me that they made a payment and there's no record of it. Can you help me find this payment and why there's no record of it?
According to law, I tendered the payment, and I don't know if there's some type of mix-up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able. They even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information. And then they might be able to track the payment and figure out where it went if you made the payment.
All right. Can you hold one moment while I get the information? Thank you kindly.
Okay. Excellent. Very good timing. Ms. Ballard, were you able to locate some materials regarding that matter?
Yes. So let me just turn on my camera real quick. One moment. Okay. filed a notice
Yes,
of
ma'am.
tender payment, a notice of tender into the courts, into the courts, and yeah. So to settle this account, I did file to the courts and to the courts, and I'm sure you can see the affidavit in there. The affidavit and it has proper endorsement. It has proper endorsement. It's been properly endorsed. And if you like, I mean,
Ms. Ballard, can you tell me the case number on that? Can you tell me the case number on that? 2023 CV 39011 or is it the 23 ED 284 322 case number?
It's 23 ED. It's 23 ED 3284.
Okay.
322.
Okay. Give me a moment to look in the file. Give me a moment to look in the file. Okay. See what I can locate. Okay. Thank you for your patience as I've sort of worked through this.
This segment delivers the turning point of the hearing. The judge locates the so-called tender of payment filing and carefully analyzes its substance, only to uncover that no actual legal tender was submitted. What initially sounded like compliance is reframed as a document rather than real payment. The courtroom dynamic shifts dramatically here, as procedural misunderstanding starts outweighing the defendant's legal assertions.
Ms. Ballard, Ms. Akpati, I was able to locate the filing. I think Ms. Ballard was referencing. I think I was that Ms. Ballard was referencing, which is a notice of tender and close account to settle and close account.
Yes.
And is that the thing you were referencing, Ms. Ballard? Is that the thing you were referencing, Ms. Ballard? That was filed. It was filed in. Okay, that was filed. It was filed in December the 12th. The magistrate court on December the 12th. Okay.
Yes, that is correct.
Okay. My review of the notice that you filed. So first of all, I've spoken with the clerk of court. So first of all, I've spoken with the clerk of court. And they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, and they can find no record of payment. And they can find no record of payment. More importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is that money would be. Like it doesn't appear that you actually submitted legal tender. It doesn't appear that you actually submitted legal tender or satisfy of any sort to pay. You instead submitted some sort of signed. Some sort of authorized representative. But no money order, documents, no check, but no money order, no check. Which I don't think they take, no certified check, anything like that. Is that an accurate statement? Am I correctly understanding what you filed? Am I correctly understanding what you filed?
Filed a tender payment. Filed a tender payment.
The law says that I can tender a payment. The law stated that I can tender a payment. It never stated to pay it. How? So, to pay it. So I did. I fulfilled the contract. I did based on the order. I fulfilled the contract based on the order.
Ms. Akpati, other than the motion that you filed, and your statements here that there has not been a payment, and your statements here that there has not been a payment. What is your position on behalf of your client on this matter?
My position is that this matter should be dismissed. Ms. Ballard has to comply with the order. Ms. Ballard has to comply with the order of the court before filing this appeal.
Ms. Ballard. Ms. Ballard, I understand. First of all, thank you for helping me understand what it was you filed. First of all, thank you for helping me understand what it was you filed. Because originally, when you were saying a money order or something like that, I was looking and I was not fine. I have reviewed what you filed. Now that I understand what you filed. Now that I understand what I was supposed to be looking at. Due respect, ma'am, but it is not. Due respect, ma'am, filing is not. That says I hereby tender payment. That says I hereby tender payment. That is not actually accompanied recognizable in legal acceptable recognizable in the United States. Legal acceptable then you have not in the United States a payment. Then you have not made legal definition that I am payment under any legal definition. So as a result of that, and Ms. Ballard, I will speak. And in a moment I'll let you respond. And if you would like, I'll let you respond. If you would like, but you have to let me finish. So.
Thank you.
As I was saying, so the motion, as I was saying, to dismiss. The motion, I think, is to dismiss the appeal of dispossessory. The appeal of dispossessory, and to dispossessory affidavit in dispossessory, which would seem to be appropriate here because there's been no payment made, and in the absence of a payment, no appeal. And that is the position that D23 is taking. Would you like to respond to that before I rule? Would you like to respond to that before I rule?
Yes.
Ms. Ballard.
So, yes.
I mean, on the order,
it did not
I
specify.
mean, on the order,
it did not
how
specify
to pay.
how to pay a payment.
Which species
is on there to pay. It was not specific.
is on there to pay. It was not
I'm
specific.
sorry, are you saying it wasn't specific in amount?
I'm sorry,
are you saying it wasn't specific in amount or it wasn't specific in
Yes.
method?
In method, yes.
Okay. I disagree. This is a standard order. I disagree. And the vast majority of everyone I've ever dealt with, the vast majority of everyone I've ever dealt with, understands that when it says tenant must, understands that when it says tenant the following payments into the court registry, make the following payments into the court registry. Everyone understands by the time specified that everyone understands that means that I've typically dealt with that means legal tender in the United States, that is recognizable as legal tender in the United States, or a money order, which would either be cash or a money order, and in the absence of those things being paid, in the absence of those things being paid, the court wouldn't have any choice but to dismiss. The court wouldn't have any choice but to dismiss the appeal.
I gave you a bill of exchange, which is the same. I gave you a bill of exchange, which is the same. I gave you a bill of exchange, which is the same.
No, ma'am, it's not. A bill of exchange is not recognized as legal tender in the United States, is not recognized as legal tender in the United States, and therefore it would not satisfy the requirement that tenants tenant into the court registry. Must make the following payment of the court registry.
Kind to confirm will you be so kind to confirm under what
for that reason I am dismissing case number.
I mean, ma'am, I object your. I mean, I object your. I mean, I object. It's there. I mean, under what law does it say that it is under not what law illegal does it say that it payment. Is not illegal tender payment?
So
illegal tender.
So, in all honesty, I don't know the answer. I don't know the answer. But Ms. Ballard, it's your obligation. But Ms. Ballard, it's your obligation the information that the court requires in order in order to understand your case, to accept your case, understand your case. You have not provided me, and you have not provided documentation or a legal citation that would provide me with some sort of basis to accept your sort of providing me with this note of exchange, providing me with as legal tender exchange, as I said, legal tender. My understanding of the law is my understanding of the note of exchange is not legal tender recognized in the United States. Note of exchange is not legal tender recognized in the United States.
You have not provided me an answer. You have not under what?
Yes, ma'am, I did. The answer I gave you was, ma'am, I did. The answer I gave you was, ma'am, I need to finish what I have to say. Ma'am, I need to finish what I have to say. How can you make a ruling? How can you make Ms. Ballard, you've been muted. Thank you. Because you continue to speak over me, which is disrespectful. Because you continue to speak over me, which is disrespectful to the court. Ms. Ballard, you are continuing to speak, and you are continuing to speak, and Ms. Ballard, I understand that you do not like the outcome. I understand that you do not like the outcome. I understand that legal tender notice of exchange that you gave me, but it gave me should answer to this question is that the order that was entered to this question is that the order that was entered payment tenant must make the following payments into the court registry made. There were into the court registry made. Filing that you submitted registry and the filing that you submitted does not constitute into the court registry and does not constitute into the court registry and does not constitute that you make a payment into the court registry that you make a payment into the court registry. The case is going to be dismissed. The case is going to be dismissed. Case number 2023 CB39011. Case number 2023 CB39011 will be dismissed for lack of anything else that the parties need. Anything else that the parties need. Ballard, you may pursue whatever appellate rights. Ballard, you may pursue whatever. Obviously, you wish to pursue. Obviously, I'm sorry, Ms. Ballard. I did not. Sorry, Ms. Ballard. You can't know. I did not know is the unacceptable response. Saying you don't know is the unacceptable response. Ms. Ballard, as I said, my answer was, Ms. Ballard, as I said, my answer was to case law. If you would like to direct me that what you submitted is legal, says that what you submitted is legal, Ms. Ballard. It is unacceptable for you. It is unacceptable for you. This matter is adjourned. Ms. Ballard, you may pursue whatever appellate remedies you'd like to pursue, whatever appellate remedies you'd like to pursue.
And we're going to have this
Thank you, Your Honor.
You guys are very
Thank you, Your Honor.
Where legal interpretation, authority, and emotion collide. The debate over what qualifies as legal tender reaches its peak, and the judge firmly rejects the bill of exchange argument, leading directly to dismissal. Interruptions, objections, and the muting of the defendant intensify the drama, ending with a decisive ruling that closes the case while leaving clear procedural lessons behind. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.